broadcast is now starting. All attendees are in listen-only mode.
Yes. Hi, everybody. My name is Tony Martinez with Latino Tax Professionals Association. I've been an enrolled agent since 2014. And here at Latino Tax Pro, we've made it our mission to work with tax and accounting professionals who serve immigrant clients, whether immigrant clients here on visas, whether they're residents, whether they're non-residents, whether they're lawfully present, whether they're unauthorized, undocumented, not lawfully present, any which way. If you have immigrant clients, we want to work with you to better serve them. Why? Because the IRS does not really care if they are here legally or not, or to the extent of their immigration status. They just want to make sure they file accurate tax returns and pay their fair share of taxes. And that's why we made it, again, our mission to bring together resources and information around this community. It's currently at 44 million strong. There's 44 million immigrants in this country. And every year, the U.S. admits 1 million new immigrants, whether lawful. And this is actually the lawful number, the legal number. 1 million new immigrants come in lawfully to this country. And so they have different tax implications, different tax situations. And we aim to address a lot of those today, but also during the multiple webinars we are doing with CPA Academy. But let's get started. Today's presentation titled Resident versus Non-Resident Alien Taxation Implications. If you have any questions during the presentation, please type them into the question box, and I'll either answer them during or at the end. And a lot of the questions I may not get to, but I'll be sure to follow up with you in the next few days via email and get the answers to your questions that you're looking for. So the objectives of today's presentations: number one, you'll learn who the IRS considers an alien. Number two, you'll distinguish between a resident and non-resident alien. Number three, you'll understand the substantial presence tests. You'll also understand the green card test, and you'll learn how residency impacts your clients. Green card test. Right before the IRS, before they work with the immigration department, there was a lot of confusion about the green card test and what that stands for. And so immigration has a definition for immigrants as aliens, and IRS has different definitions for immigrants as residents and non-residents. But the best thing to understand is your client an alien? What does that mean? Sounds funny, right? But the IRS considers all individuals who are not U.S. citizens, U.S. nationals, or U.S. citizens or nationals aliens. If your client is not a U.S. citizen or national, they are either considered a non-resident alien or a resident alien. You are a resident alien of the U.S. for tax purposes if you meet either the green card test or the substantial presence test for the calendar year. So keep that in mind. The green card test. You are a resident for U.S. federal tax purposes if you are a lawful permanent resident of the U.S. at any time during the calendar year. This is known as the green card test. You are a lawful permanent resident if you have been given the privilege according to the immigration laws of residing permanently in the U.S. as an immigrant. You generally have this status if the U.S. Citizenship and Immigration Services issued you an alien registration card, Form I-551, also known as a green card. You continue to have U.S. resident status under this test unless you voluntarily renounce and abandon the status and writing to the USCIS. Your immigration status is administratively terminated by the USCIS. Or your immigration status is just judicially terminated by a U.S. federal court. So, in short, if the Immigration Services considers you a lawful permanent resident under their definition and you have a green card, then the IRS will consider you a resident for tax purposes. So that's an easy one to know, right, to understand. We have come to our first polling question to see if you're paying attention. You could answer them wrong. We just want to make sure that you are here and you are paying attention. First polling question, very easy. Are you ready for tax season? Yes, let's do this. Somewhat, I need more training, or no, I need help. I need more information. Please take a second to answer a polling question to be able to receive continuing education hours for being with us today. We'll leave it open for a few more seconds to give you time to vote or to give us your polling answer. Let's go ahead and close it. Let's share it. So most of you are saying, yes, let's do this. Some of you need more training and a few of you need help. So no worries. That's why we're here, right? We're looking to update you and get you all the information that you need to be successful this tax season. Cool. So I took off my jacket. It's getting kind of hot in here. Let's dive right into the substantial presence test. The substantial presence test helps you understand. Here we go. The substantial presence test is a second test regarding residency. You will be considered a U.S. resident for tax purposes if you meet the substantial presence test for the calendar year. To meet this test, you must be physically present in the U.S. on at least 31 days during the current year and 183 days during the 3-year period that includes the current year and the 2 years immediately before that. Counting all of the days you're present in the current year, 1/3 of the days you're present in the first year before the current year, and 1/6 of the days you're present in the second year before the current year. Now, what does that mean? The term U.S. includes the following areas. So when somebody says you must be physically present in the U.S., in the United States, what does that encompass? And it's all 50 states in the District of Columbia, the territorial waters of the U.S., the seabed and subsoil of those submarine areas that are adjacent to the U.S. territorial waters and over which the U.S. has exclusive rights under international law to explore and exploit natural resources. The term does not include U.S. possessions and territories, so it does not include Puerto Rico, does not include Guam, does not include the Virgin Islands, and it does not include U.S. airspace. So keep that in mind. That's very important as you're looking to consider residency or to calculate the number of days your clients are physically present in the U.S. The term U.S. has these implications. To better understand the substantial presence test and that crazy calculation I was looking to describe earlier, let's look at an example. Let's look at Susan. Let's say Susan travels to the U.S. for business. She's here often. In 2016, she spent 312 days in the country. In 2017, she spent 210 days. This year, 2018, she arrived on August 1st. Now the question is, how many days does she need to stay in the U.S. to meet the substantial presence tests? Let's look at this table. So in 2016, we count only 52 days towards the calculation of the substantial presence test. Why? Because 52 is 1/6 of 312. In 2017, we count 70 days. Why? Because 70 is 1/3 of 210 days. And for the current year, so she got here August 1st, she arrived. She was physically present, right? She wasn't in U.S. airspace. She landed. And I know it sounds kind of funny, but that's key, because if she is flying around at 11:55 p.m., once you land at 11:55 p.m., even if it's near the end of the day, the IRS considers that you've been here that entire day. So they will count that as a day, physically present in the U.S. So if she's in the sky, she may want to fly around until it hits 12:01, right, to be technically the next day. But when does she need to depart to to ensure that she doesn't hit the substantial presence test, to ensure she doesn't hit those 183 days. So the answer is, if you look at the table here, by September 30th, because by September 30th, it is 61 days that she's been here, 2018, the current year. Why does 61 days matter? Because 61 plus 70 plus 52 is 183 days. And at that point, she has met the substantial presence test. Now, does she become a resident on September 30th? No. If she meets the substantial presence test this year, it doesn't matter which day, if she meets it on September 30th, if she meets it on December 31st, if she meets the substantial test, a presence test, any day of the current year, she will be considered a resident as of January 1st of the year. So if she meets it on September 30th, she's considered a resident as of January 1st, 2018. Because a taxpayer becomes a resident on the first day of the year they meet the substantial presence test. Susan will be considered a resident for tax purposes, and her worldwide income will be subject to federal tax, to U.S. federal tax. And that's the reason why individuals are looking to avoid becoming residents if they don't have to be residents, because residents are treated just like U.S. citizens for federal tax purposes, in the sense that their worldwide income is subject to federal income tax. So she may not want that to happen, right? Maybe she has assets in Argentina and South Africa and India. She doesn't want those incomes to be subject to federal income tax, to U.S. federal income tax. Maybe she doesn't even want to let the IRS know which assets she has across the globe. So she will be paying very close attention to that day, that September 30th, or that 183rd day. And you, as a tax professional, as an accountant, as a professional, you must also keep that in mind. Also, did I go over anything about her immigration status? Is she a visa holder? Is she here lawfully, unlawfully? No, right? Because it doesn't matter. The substantial presence test does not take into consideration immigration status. It just takes into consideration days physically present in the U.S. And again, for terms of considering the U.S., remember, that includes 50 states, the 50 states in the District of Columbia, territorial waters of the U.S., the seabed and subsoil that are adjacent to the territorial waters of the U.S. It does not include Puerto Rico, Guam, Virgin Islands, any of the territories. So she may want to, if she is, for whatever reason, getting close to that substantial presence test day, she may want to hop to Puerto Rico, all right, and maybe be there a couple of days. Whatever the case may be, it's all part of tax planning. So keep that in mind. Let's look at another example of another individual who meets the substantial presence test. Jose has been here for over 10 years. He is unauthorized, he is undocumented, he's not lawfully present in the country. So he does not meet the green card test, right? According to the immigration laws of this country, he shouldn't be here. He does not have the authority to be here, so he's unauthorized. So no green card test, he's not going to meet that. However, he's been here 10 years. He hasn't left. He meets the substantial presence test. So he needs to file Form 1040, not 1040NR, 1040. He's a resident. And that's a lot of I see that often, working with a lot of our members, with a lot of tax professionals. They think, oh, you're illegal, you have an ITIN, you're not a resident. Let's do 1040NR. Mistake. If they are here long enough to meet the substantial presence test, their immigration status does not matter. They are going to be residents for tax purposes. You file Form 1040. Many people think that immigration status is directly related to residency, and it's not. Although the immigration laws of the U.S. refer to aliens as immigrants, non-immigrants, and undocumented aliens, the tax laws of the U.S. refer to these individuals only as residents or non-residents. The IRS does not care if you're documented, undocumented, authorized, not authorized. They will tax you. So encourage your undocumented, unauthorized clients to file accurate tax returns and pay their fair share of taxes. That's why we're here. That's why you're here, to ensure we guide these individuals that want that are working, that are contributing to the country, that to pay their fair share of taxes, right? Now, they're not supposed to be here. That's a different story. Let immigration take care of that. I see there's some questions coming in. Maybe let's answer a few here before I jump to the next topic. Again, if you have any questions, please type them into the question box. So how does Jose fill in the Social Security number on the 1040 if he doesn't have a Social Security number? Great question. In that case, Jose needs to apply for an ITIN, Individual Taxpayer Identification Number. A lot of people also make the mistake with the ITIN, thinking that ITIN just means that somebody is here illegally or unauthorized. The only purpose anybody needs an ITIN is because they, for whatever reason, do not have or are not eligible to apply for a Social Security number. So in this case, Jose, he's undocumented, unauthorized, he's not able to apply for a Social Security number, then he could go ahead and apply for an ITIN on Form W7. But that's the case of anyone else, even if somebody is here lawfully. It could be the spouse of a J1 visa. It could be the spouse of a J1 visa. They're usually here on a J2 visa. Maybe they do not have a Social Security number. The J2 visa, they don't have Social Security numbers because they're not here. They're not really here to work, right? So the IRS may not even issue them a Social Security number. So in that case, they need to apply for an ITIN also. So again, if somebody has a tax reporting obligation, a tax filing requirement, and they do not have a Social Security number, they must apply for an ITIN, and you add that ITIN on the same field, the same box that you're supposed to add an individual's Social Security number. But great question. Are there any federal laws that would prohibit me from preparing tax returns for undocumented individuals? So our job as tax professionals, and then if you follow Circular 230, again, is to file accurate tax returns and ensure that our clients are reporting all the income that they are receiving. And so our jobs are simply to do that for the clients, because the IRS wants individuals to report that income. Now, it could get a little tricky. Let's give another scenario. What if somebody comes to you and says, I am selling drugs and I want to report these drug sales. Could you help me? Technically, they're supposed to report all income generated, right? So you could go ahead and file that tax return. Now, do you want to? It's gray area, right? You may not even want to take that risk, because even though you're doing your job and you're filing accurate tax returns, you don't want to maybe even deal with those type of clients. So it's up to you. But to answer your question, serving undocumented, unauthorized clients, there's nothing wrong with that. You just simply need to ensure that you are filing accurate tax returns. I mean, it gets to the point where when we have clients here at our office that are undocumented, they're coming in with a W-2 that has a different Social Security number on it. I don't know how they got that fake Social Security number, but they're using those Social Security numbers that are technically fake, fraudulent, right, to work, and they're coming in with W-2s with those numbers on them. We just need to make sure when we file the 1040 that the 1040 has the ITIN that belongs to that taxpayer. And we then include the W-2 with that other number on our software. We send it in. The IRS takes it. The IRS will accept it. All the IRS wants to know is that that individual actually earned that income, that they are not making up numbers. And IRS is accepting W-2s with different Social Security numbers on them, as long as the taxpayer could prove that they earned that income, even if they earned it by breaking the law. So that's where it gets a little sticky. And I see a lot of questions coming in, but let me continue the presentation, because I'm going to get really derailed here on all these different scenarios and all the different, and I don't want to go off too much on a tangent. But great questions. Please keep on bringing them in. We talked about Jose. Get these notes out of the way here. So you are treated as present in the U.S. On any day you are physically present in the country at any time during the day. However, there are exceptions to this rule. Do not count the following as days of presence in the U.S. for the substantial presence test. So do not count days you commute to work in the U.S. from a residence in Canada or Mexico. If you regularly commute from Canada or Mexico, do not count days you are in the U.S. for less than 24 hours when you are in transit between two places outside of the U.S. So if you are you're going between Australia and Italy, and you're doing a layover in the U.S., for some reason, if you're just going, and maybe Mexico, maybe a better example, Mexico and the UK, and there's a layover in the US. If you're in the US less than 24 hours and you're just in transit, maybe there's a layover, do not count that day, that particular day, as being physically present in the US. Do not count days you are in the US as a crew member of a foreign vessel. Do not count days you are unable to leave the U.S. because of a medical condition that develops while you are in the U.S. And do not count the days you are an exempt individual. If you exclude days of presence in the U.S. for purposes of the substantial presence test because you are an exempt individual, so let's say you are a J1 visa holder and you are a student, you are exempt for up to 5 years from being a resident. So it's not until the 6th year that your calculation for the substantial presence test begins. So if you're an exempt individual, or if you were unable to leave the U.S. because of a medical condition, let's say that you are visiting and you are here temporarily and you have, unfortunately, you may have a heart attack, or there's a medical condition that you have to stay in the U.S., you cannot leave, you need to use Form 8843 to have those days excluded from the calculation of the substantial presence test. That's the purpose of Form 8843. If you also, again, are an exempt individual because of your visa status, you also use Form 8843 to have those days excluded from the calculation of the substantial presence test. If you do not, so you'll send in 8843 with your 1040. But if you don't have to file for whatever reason, if you don't have a U.S. tax filing obligation that year, maybe you didn't earn any money or you didn't earn enough, then you simply send in Form 8843 by itself to the IRS Service Center in Austin, Texas, by the due date of the return. So make sure you send that in on time. Even if you have to send that in by itself, send that in. Because if you do not send that in, you will not be able to exclude any of those days that you are looking to exclude. So that's very important for those of you that are looking to exclude days for the purpose of your certain visa status, or if you're here because of a medical condition, you cannot leave the country, use 8843 to exclude those days. And again, if you don't file that on time, you will not be able to exclude the day. So keep that in mind with your clients that are exempt. Time for another polling question. The next polling question is, which of the following is not considered the United States for the purpose of the substantial presence test? Is it the territorial waters of the U.S., Puerto Rico, Hawaii, or D.C.? Which is not? Please answer the question to see if you're paying attention. Few more seconds. So which of the following is not considered the U.S. for purposes of the substantial presence test? And the answer is Puerto Rico, because U.S. possessions and territories are not considered the U.S. when we are covering the substantial presence test. The territorial waters of the U.S. are considered part of the United States for this test. So is Hawaii, as it is a state, and so is the District of Columbia. Good job, everybody. Now, what if you have a client who, is here long enough, they meet the substantial presence test, they are considered residents, and they have income in a different country, and they have income here. Let's say they have income in Argentina. And you're like, oh man, I'm going to be subject to double taxation. The authorities of Argentina are taxing me on this income, and now the U.S. is going to tax me. So for the foreign tax credit is here for that purpose. So if you paid or accrued foreign taxes to a foreign country or U.S. possession and are subject to U.S. tax on the same income, you may be able to take a credit or an itemized deduction for those taxes. This helps mitigate the potential for double taxation. You can claim a credit only for foreign taxes that are imposed on you by a foreign country or U.S. possession. If you choose to take this as a deduction, enter the amount on line 6 of Schedule A, titled Other Taxes. Now, this, if you look at the Schedule A, the new Schedule A, at least the draft Schedule A, we're still waiting to get the final Schedule A. But in the current Schedule A for 2018, line 6 is not part of the $10,000 cap. It's not part of the $10,000 SALT cap. So that's different. So you could go on Schedule A, line 6, add it there. Now, but what if your clients don't itemize, right? This year, the standard deduction has gone up for 2018. So we are going to see less individuals, less clients itemizing. So if you're like, oh man, I can't itemize, what do I do? You could also take it as a credit. So if you choose to take this as a credit, enter the amount on line 48 of the new Schedule 3. So there's a new Schedule 3, so you want to add it to line 48 of the Schedule 3. At least the current draft form, these numbers may change when we receive the final forms, but the current draft forms, it is on line 48 of Schedule 3, and this flows to line 12 of the new 1040. That's where the credit's going to flow in. It's a non-refundable credit, so it will lower your tax. Keep in mind that these are current draft forms and the numbers may change, but as it stands right now, as of this morning, it's line 48 of the Schedule 3 that flows into line 12 of the new 1040. In most cases, the taxpayer sees the biggest benefit when taking the credits. This is because a credit reduces your actual U.S. income tax on a dollar-for-dollar basis, while a deduction reduces only your income subject to tax. You also do not need to itemize to take the foreign tax credit. Again, some of our clients are not going to need to itemize anymore. With the increase in the standard deduction for the year, we may see less clients doing that, less clients itemizing. Keep in mind that if you choose to take the credit, you must take the credit for all qualified foreign taxes. You cannot choose to take the credit for your taxes that you paid in Argentina and then for some reason take a deduction on Schedule A for the taxes that you paid in China. Or whatever, right? So if you're going to do credit, you do all the credit. If you're going to take it as a deduction, do all the deduction. But again, with my clients, I usually encourage them to take the credit. It helps mitigate the potential for double taxation in that sense. So there is something that can be done. If you have clients who have been here long enough and they meet the substantial presence test and they're residents and they do not want to pay double taxation on their income, they could go ahead and file Form 1116, the foreign tax credit. Let's look at a scenario here. So we have a client that comes in every year. But last year they came in, they're married, husband and wife. They are from Australia. They are here on a green card. They're permanent residents, so they are lawful permanent residents. They have a green card. and they have an S corporation. Their business it's a software business, very successful. They come in, and but this past year, the wife came in and was going over her scenario with us, and she was basically saying, look, I didn't bring my husband because I'm here by myself, and I want to figure out like what to do if I leave the country, because I'm really considering leaving. I'm tired of my husband. I'm tired of the business. I'm tired of everything. I want to leave, go back to Australia, start a new life. What are my tax implications? So she had the sense of actually coming to us before she made any drastic decision, right? And how many times do our clients come to us after they make big decisions, even though we try to tell them, come to us before. Don't sell your home. Don't sell your business. Don't bring in a new partner. Don't do anything drastic, financially drastic at least, right? Without consulting us first so we could give you some guidance. So she had the sense to come in before she decided to make that decision. So she comes in and says, what's going to happen to our S corporation if I leave the country and give up my residency? Because that's basically what she was asking. I want to leave the country, go back to Australia, give up my residency, and start a new life. And so we made it very clear, well, what are your 5-year goals? Are you looking to just go there for a while or be there forever, start a new family? And then she then responded, I just told you, it's forever. I'm leaving forever. Okay. So then we let her know, if you give up your green card, your residency, your S corporation may lose its S election and may convert back to a C corporation. Why? Because to be a shareholder of an S corporation, you must be a resident of the U.S. So as soon as you give up your residency, your green card, and you leave, your S corp becomes a C corp subject to double taxation. And that's going to affect the other shareholders as well. Now, given that the other shareholder is her husband, that's the only shareholders that are there. But the point of this story is that residency does not just impact individuals, it also impacts businesses and entities. So to build on this example, if she was one of 100 shareholders of the S corporation and she decides to give up her residency, but she still remains a shareholder, right? The other 99 shareholders will then be impacted by her decision. Then the entity will then become a C corp because it'll lose its S election. Because again, to be a shareholder of an S corporation, you must be a resident or a U.S. citizen. So residency also impacts entities, so keep that in mind. Just like another example to help us understand residency. Let's say Kuman is here on an H-1B visa. He's here from Korea. He works for Microsoft. So for those of you that may or may not know, an H-1B visa gives you a social security number. You're authorized to work in the U.S., but you're only authorized to work. You're restricted to work in the capacity that the visa was issued to you. So Microsoft will then apply for a visa for Kuman and basically say you need to work for Microsoft, and that's why you're here. You cannot go and work anywhere else, or you can't go and do anything else. So he's in the country, he's doing great, he's working for Microsoft. It's going to restrict him to the job duties required by his employer. But during the course of his employment at Microsoft, he meets some friends, some colleagues there, some coworkers, and one day, one of his friends asked Kuman, "Hey Kuman, could you build me a website? I notice you're really good at building websites for Microsoft. Could you do one for me for my business or just for me? Build me a website." Okay, Kuman says, "Yeah, why not?" He does it. He does a good job. His friend says, "Oh man, thanks Kuman, you're the best. Here's $100 or here's $500. I know you didn't ask for it, but I want to hook you up. I want to take care of you. You helped me, I helped you." Kuman said, "Cool, $500. Okay, nice." And then word gets out that Kuman is a great website designer. So other friends ask Kuman and approach Kuman, "Hey, could you build me a website? Could you build me an app? Could you build me a platform or whatever?" Yeah, cool. Kuman does it. And he starts getting money. And he starts to realize, hey, I could turn this into a side business, into a side gig. So he does. So Kuman, from 9 to 5, he's at Microsoft. And then in the evening or on the weekends, he's building websites. Maybe he has the skills to build apps, and he's doing that for other people, and he's charging them, and he's getting paid. He starts making a lot of money. Now, the question is Kuman able to do that? Because Kuman's going to walk into your office, and he's going to say, I have a W-2 for Microsoft. Here's my social security number. I'm authorized to work. But I also want to report my income from my side business, my side gig. And this is how much I made. And you may be wondering, why would Kuman report that? Shouldn't he kind of hide that? I mean, obviously he should report that, but you may be thinking, that's interesting that he makes that decision to be a good citizen or a good resident in this case and report his income. Well, you got to understand the psychology of a lot of the visa holders. They're here and they know they're here temporarily and they want to do things right. They don't want to risk anything. They don't want to risk their visa being revoked. They don't want to do anything that's risky. So they're going to go and say, he's going to come to you as a professional and he's going to tell you, I want to report the income. Here's how much I made. And so you do that. You do it on the Schedule C. So he files his W-2 for Microsoft. You do the Schedule C, and you do the expenses, and you send it in. The IRS says, perfect, good job, Kuman. You've completed your duty as a great resident, and you've filed accurate tax returns, and you reported all your income. Now, so that's great. So now the next year, Kuman comes back and says, I'm making even more money on my side gig. I heard that if I become an S corporation, I could maybe save on some of the Social Security tax and Medicare tax. Because by the way, H-1B visa holders are subject to Social Security and Medicare tax. So Kuman hears from somebody that he should become an S corp. Now, is Kuman able to become an S corporation for his side gig? Should Kuman become an S corporation? Should he stay a Schedule C? And that kind of, not to confuse you, but I'm going to give you a polling question to get your feedback, and then I'm going to finish the scenario. So my question to you is, what would you advise Kuman to do when you know he's going against the visa, he's breaking the rules, but he wants to report the income? Should he become a C corporation? Should he stay a sole proprietor and apply for maybe LLC protection, right? That's always a good option. Should he go back to his country or don't report the income? What would you advise Kuman to do? Please answer the polling question to get your feedback and also to be able to gauge that you are with us and you are paying attention. But based on your answer, it's going to help us finish the scenario so we could all understand what to do with Kuman. Few more seconds. Let's go ahead and share the results. So some individuals said he should become a C corporation. Some individuals said stay a sole proprietor and apply for LLC. Go back to the country, don't report the income, nice little mix. So great. Thanks for your feedback. Now let's finish the scenario. So, first of all, could Kuman even be an S corporation? He's here, he has a social security number. But the question is he a resident? So he is not a green card holder because he is considered what they call a non-immigrant. So he is here only on a temporary basis and he is expected to return to his country of origin. In this case, it's Korea, when his visa expires. So only permanent residents are given green cards, lawful permanent residents. So he does not meet the green card test. But let's say he's here long enough to meet the substantial presence test, and he does become a resident. Let's say he's here long enough to meet the substantial presence test. He's here long enough to become a resident. So could he still become a shareholder of an S corporation? Of this S corporation? Yes, why not? Right? He has a social security number. He's here long enough to become a resident. Given he's breaking the rules of the visa, but there's nothing wrong. There's nothing in the law that says that he cannot be a shareholder of an S corporation because he meets the qualifications to do so. Now, Microsoft finds out, let's say, months pass by, Microsoft finds out that he's doing this side gig. They revoke his visa. Immigration Services revokes his visa after Microsoft then maybe puts him on alert. And then he's basically subject to deportation at that point. Kuman, you got to go. Kuman says, I'm not going anywhere. I'm making $1 million on my side gig every year. I'm going to stay here even if I'm breaking the law. So Kuman decides to stay in the country. They revoke his social security number. They revoke his visa. He's not authorized to be in the country. Now, could Kuman still be a shareholder of an S corporation? He's still a resident, right? Because remember, for the substantial presence test, residency has nothing to do with his immigration status. So he's still a resident by the substantial presence test. However, he is not authorized to be here. He does not have a social security number. So guess what? He cannot place himself on payroll because he's going to be knowingly hiring an illegal, unauthorized individual. So that's the reason he cannot be an S corporation anymore. It's not because of residency, because he's still a resident, even though at this point he's undocumented, unauthorized. He's still a resident by the substantial presence test. But he is unauthorized. He's illegal. So he cannot place himself on payroll. So what happens? He then reverts back to being a C corporation at that point. He's not an S. He loses the S election. He becomes a C corp. You know, as a C corp shareholder, he could be an ITIN holder, etc. Or maybe he just goes back and becomes a sole proprietor. So, but that's kind of the tax planning you need to do with some of these clients. So when Kuman comes in and he admits to you he's breaking the rules, he's going against his visa, you may want to be proactive and you may not want to make him an S corporation, knowing that in the future he may lose that S election. You may from the beginning want to make him a C corporation, or you may want to keep him as a sole proprietor, maybe with an LLC protection at the state level to ensure that he continues his business if and when his visa is revoked. And Kuman may be coming into you. He knows the risk, and he tells you, man, I'm making a lot of money. I'm making $1 million through designing websites. I want to do it right. I'm already breaking one rule with the immigration department or services. I don't want to get the IRS pissed off. So I want to do things right. So this is an example of scenarios that happen every day. And so by being proactive and understanding the different rules that apply to these immigrant clients, you guide them the right way. So our job is to guide them the right way. Our job is not to scold them. Our job is to tell them, you shouldn't even be doing that. You're breaking the rules. Because again, it doesn't matter if he's breaking the rules. The IRS still wants him to report all the income that he's generating and file accurate tax returns. So keep that in mind. Here's some questions about these aren't days here under the H-1B excluded from days counted for substantial presence test. So an H-1B holder is not one of the visas that is excluded from the substantial presence test. So as soon as Kuman gets here on the H-1B visa, his time will start ticking regarding the substantial presence test. The ones that are excluded are like the A and G visas. Those are for diplomats or employees of government entities. And then you get your J1 visas are they are excluded, but for a number of days. So it gets interesting. And again, we have another presentation on non-immigrant, non-resident visa holders, and I'll add it to the chat box here for you to see it with us. And it goes right into all these different scenarios. But let me go ahead and continue because I don't want to run out of time before I finish the day. We talked about the polling. Thanks for contributing to the polling question. That was very helpful. Non-resident aliens, let's talk about them now. Non-resident aliens pay tax only on U.S. income and are exempt from self-employment tax. Non-resident aliens who are required to file an income tax return must use Form 1040-NR or 1040-NR Easy. Wages paid to non-resident aliens employed within the U.S. by an American or foreign employer in general are subject to Social Security and Medicare taxes for services performed by them within the U.S., with certain exceptions based on their non-immigrant status. So like the H-2A visa holders are not subject to Social Security and Medicare tax. The J-1 are not. But the H-1B visa holders, in Kuman's example, he is subject to Social Security and Medicare tax. You may also get clients that come in the door with the Form 1042-S. What is that? You may get confused. Oh, what do I do? 1042-S. So a 1042-S is used to report amounts paid to a non-resident foreign individual or anybody that's presumed to be foreign that are subject to income tax withholding. This is the most common. You may see it amongst graduate students at your local university. If they're immigrant graduate students on visas, they may have 1042-S. I've also seen it, surprisingly enough, with some of the ITIN clients, the individuals that are here that have been here for a long time. Maybe they go to the casino, they win big, and they do not give the casino, well, they don't give them a Social Security number because they don't have one, and they may not even want to give them an ITIN because, you know, they, again, understand the psychology of a lot of these immigrants, especially those that are here unauthorized and undocumented. If you go and you win like $500,000 at the casino, man, you start getting scared. You're like, whoa, great, a lot of money, but now people are going to find out. The government's going to know. And so you go and then the casino rep says, what's your Social Security number? You're like, ooh, I don't have one. Well, do you have anything else on ITIN? No, I don't have one. Just give me my money, right? And so they're gonna, if they do not give that individual any number, they're gonna withhold 30% of the earnings that they won, and then issue a 1042-S. So you may have an ITIN client coming in, even though they're a resident for by the substantial presence test, they come in, they're like, you know, I didn't want to say anything when I was at the casino, but I have an ITIN, and here's the 1042-S. And so you simply report the income and the withholding. That's all it is. So it could just income and withholding. So again, 1042-S is for those individuals that have that are subject to income tax withholding that are foreign individuals. In summary, make sure to keep track of all the days of your clients, your immigrant clients. If they are non-residents and they are here, they're coming either for business or for any reason, they're maybe visa holders. Keep track of those days that they're physically present in the U.S. because as soon as they become residents, they are subject to the same tax laws as a U.S. citizen, which means that their worldwide income will be subject to federal income tax. If applicable, file Form 8843 on time. Do not miss the deadline, because if they do exclude some of those days, you want to use Form 8843 to let the IRS know which days will be excluded from the calculation of the substantial presence test. Remember also that unauthorized, undocumented individuals may be residents for tax purposes. And there's different situations where you may have here for example, a DACA recipient, the Deferred Action for Childhood Arrivals. It's a DACA individual. They are here. They may be residents. They may have a Social Security number. They may be authorized to work, but they are not lawfully present. So DACA individuals are not lawfully present according to the definition of the Affordable Care Act. So the Affordable Care Act does not apply to them. And then you may have other individuals that are visa holders that are also authorized to work and that have Social Security numbers, but that are non-residents because they're here on a temporary basis. And there's also like the TPS, temporary protected status. I mean, we have another presentation next week that's titled Tax Credits for Immigrant Families, where we go over the DACA recipients, the TPS, and how.
Thank you.
Bye, everybody. Thank you. And clients. And finally, also keep in mind that immigration status does not directly affect residency when working with these clients. If you do have clients who are immigrants, you may want to ask them, are you here on a special visa or on a work permit? Make that part of your interview process when they come in the door. If you want to know more about serving immigrant clients, if you want to network and rub shoulders with other professionals who are actively serving immigrant clients, we encourage you to attend Latino Tax Fest. Latino Tax Fest every summer is in Las Vegas. So next year, 2019, we will return to the MGM Grand in Las Vegas on July 30th, 31st, and August 1st. You could earn up to 21 hours of continuing education for enrolled agents, for CPAs, for other tax professionals as well. Great topics. We bring in immigration attorneys, but we also talk about cannabis and tax, virtual currencies, and other updates like Section 199A, depreciation, ITIN. Sharon Bradley usually shows up. She's the director of the ITIN department of the IRS. Carol Campbell from the Return Prayer Office will also usually joins us. So great IRS speakers, great enrolled agent speakers. And guess what? After a long day of learning, we bust out the mariachi and the margaritas and everybody's having a good time. You're networking with others. There's also a pool party. So if you're looking to attend, I recommend sign up by the end of the year. Bye, everybody. Thank you.